Hello, my name is Ellis, and today I will be presenting an analysis of landmark legal cases in higher education. These cases address Title IX, free speech, academic freedoms, admissions, and student organization policies. Together, they show how the courts continue to shape higher education and its responsibilities. In this presentation, we'll cover 5 cases. I apologize in advance if I mispronounce any of these names. Fleebleman versus Columbia University from 2020. Demers versus Austin from 2024. Yuzubin versus Przetsky from 2021. Students for Fair Admissions versus Harvard and UNC in 2023. And Christian Legal Society versus Martinez in 2010. Each case brings out different tensions in law and higher education. Our first case is Fleebleman versus Columbia University. The plaintiff was Ben Fleebleman, a graduate student accused of sexual assault. Columbia University revoked his degree and retroactively expelled him. He sued, claiming gender bias under Title IX and breach of contract because of unfair disciplinary practices. The courts reviewed Columbia's motion to dismiss, and it denied dismissal of his Title IX claim, meaning his allegation of gender bias could move forward. Fleebleman pointed to evidence, recordings, witnesses, and photos that he argued was ignored. He also argued Columbia faced external pressures to appear strict in sexual misconduct cases, especially against men. The question was whether Columbia's decision was biased against him as a male student. The court said Fleebleman plausibly alleged bias and that there was reasonable doubt about Columbia's findings. The case highlights the low threshold students need to meet to claim bias in Title IX proceedings. This case put universities in a double bind. If they act too leniently, they risk lawsuits from complainants. If they act too harshly, they risk suits from the accused. Administrators must ensure fairness, students and faculty involved in hearings must follow policy precisely, and communities must understand how external pressures can affect outcomes. Administrators must design clear and unbiased policies, especially in Title IX cases. Even the appearance of bias can lead to lawsuits. This case is a reminder that fairness is not optional, it's a legal requirement. Our second case is Demer versus Austin. The plaintiff, David Demers, was a tenured professor at Washington State University. He distributed a pamphlet criticizing his department and claimed administrators retaliated against him. A lower court said his speech wasn't protected because it was part of his job duties, but the Ninth Circuit reversed, saying that academic speech, especially related to teaching and scholarship, deserves First Amendment protection. This was important because it carved out an exception to the Garcetti versus Ceballos precedent, which normally limits employee speech rights. The question was whether Garcetti applies to professors. The Ninth Circuit said no. Academic freedom requires special protection. Instead, the courts must use Pickering tests, balancing a professor's right to speak against the institution's need to function. This strengthened protections for faculty in the Ninth Circuit. Professors can debate and critique academic structures without fear of retaliation. For administrators, the takeaway is that you cannot punish professors for academic speech unless it seriously disrupts university operations. This case reinforced that academic freedom is not just a tradition, but a constitutional right. Universities must build cultures where faculty criticism is respected even when uncomfortable. Our third case is Yuzubin versus Przetsky at Georgia Gwinnett College. A student was stopped from sharing his faith outside of a designated free speech zone. Even after following the permitting process, he was silenced again. When the student sued, the college changed its policy. Lower courts dismissed the case as moot because the Supreme Court reversed, ruling that even a request for nominal damages keeps the case alive. This ruling prevents colleges from escaping accountability by changing policies mid-lawsuit. Administrators must ensure speech policies are constitutional from the start. Students now have stronger ability to hold institutions accountable for restricting free speech. This is a major risk management lesson. Changing a bad policy doesn't erase the harm it caused. Administrators must get policies right the first time or face lasting legal liability. Our fourth case is Students for Fair Admissions versus Harvard and UNC. Filed in 2014, the case reached the Supreme Court in 2023 and reshaped admissions practices nationwide. Lower courts had upheld Harvard and UNC's race-conscious admissions policies, but the Supreme Court overruled them, ruling that they violated Equal Protection Clause. The court said race-conscious admissions fail strict scrutiny because the goals were vague, the categories arbitrary, and there was no endpoint. This effectively ended affirmative action in U.S. college admissions. Universities now must adopt race-neutral admissions. This will likely reduce minority enrollment at selective schools, creating new challenges for diversity. Administrators must find innovative, lawful ways to build diverse student bodies. That may mean focusing more on socioeconomic status, geographic diversity, or removing legacy preferences. This ruling represents one of the biggest challenges to higher education in decades. Our final case is Christian Legal Society versus Martinez, decided in 2010. This Christian legal society at UC Hastings required members to sign a faith statement, which excluded some students. Hastings denied them recognition, all because of its all-comers policy, which required any recognized student group to admit all students. CLS sued, claiming this violated their First Amendment rights. The Supreme Court ruled for Hastings, saying its all-comers policy was reasonable and viewpoint neutral. The key was that the rule applied to all groups equally, regardless of their message. This ruling affirmed that universities can enforce non-discrimination rules for student groups as long as policies are consistent. Students can still form private groups, but official recognition requires inclusivity. For administrators, this case clarified that universities can set conditions for funding and recognition, so long as they apply the rules evenly. The case also showed the difference between subsidizing speech and prohibiting it. These are the references. These are all the legal cases. In conclusion, these 5 cases remind us that higher education is deeply shaped by the law. Courts have reinforced due process, free expression and academic freedom, non-discrimination, and equal protection. As administrators, our job is to build policies that are fair, transparent, and legally defensible. Thank you for your time.